Okay, well, it's a couple of minutes past 2, so I am going to start by welcoming you all to this Devonshires session as part of our InLaws programme. I would say it's lovely to see you all, but the way that we set up these webinars, I can't actually see you, but I can see how many of you there are, and I saw the list, and thank you everyone for joining. Those of you that may be new to InLaws session, we run a programme that is targeted specifically for in-house lawyers, and it's an opportunity to network and to gain some information, and we do that by webinars, seminars, and some social events along the way. So hopefully we may be seeing you in person at some of our events in future. I'm Donna McCarthy. I'm partner and head of housing management and property litigation at Devonshires, and I head up the InLaws group. So I'm just coming today to say hello and welcome, and really excited about this session. This is to cover privilege for in-house lawyers, which as a litigator myself, I do find questions seem to arise on a number of my cases, and I'm sure that the session will be really, really helpful for all of you that are attending today. So just by way of housekeeping, this is a format where you can see us and our slides, hopefully, but we can't see you. The way that you communicate with us is by the Q&A button at the bottom of the screen, and the session will be running with our speakers covering topics for about 40 minutes with plenty of time for questions at the end with a 3 o'clock finish. And you can hold us to that. So today's session, this will be a refresher for some of you as to the main types of privilege, practical tips for application, specifically for in-house legal teams. And our speakers today are Pauline Lépissier, who is a partner and a great member of our litigation and dispute resolution team. And also Mark Baldock, who is a barrister from Three Stone. Really delighted that Mark can join us. His expertise is in arbitration, company law, commercial disputes, litigation, insolvency and restructuring. So lots of experience there for you to tap into, and I'm sure possibly some of the questions may veer into some of Mark and Pauline's practice areas too. So without further ado, before I hand over just to Pauline to say, you'll get slides, because that's always the first question I get asked. Slides will be sent round after the event. We do also send a feedback questionnaire. Please do give us lots of feedback, because that's how we shape our programme and our offering. So the more you can tell us about how you like training and networking, the better the offering will give. So and there's my housekeeping slide. So enjoy the session, everyone, and I'm going to hand over now to Pauline. Thank you.
Thanks very much, Donna. Thanks for that great introduction. Well, as Donna says, the purpose of this session is to try and provide a refresher really on the doctrine of privilege. I'm sure a lot of you will be familiar with it, but it's something that can be quite tricky and easily go wrong in practice. So always worth reminding ourselves of the key principles and components. So we'll cover legal professional privilege, comprised of legal advice and litigation privilege, without prejudice privilege, the common interest doctrine, and then some practical tips for in-house lawyers. Mark's just going to cover some of the foundations of the doctrine.
Yeah, so I think Pauline's right. It is a really tricky area, and I think it's helpful, therefore, to start with some of the foundations for both limbs of legal professional privilege, and to keep those foundations in mind when we're thinking about questions relating to privilege. So I've got there on the slide two distinct justifications that have been outlined in the cases for legal advice privilege and litigation privilege, respectively. So as Pauline will come on to say, legal advice privilege is really designed to protect communications between a lawyer and a client, made in connection with the giving and receiving of legal advice. And doctrinally, that's privilege exists in respect of those communications to really give effect to access to legal advice. And the cases emphasise, as Lord Taylor did all those years ago in the Ex parte B case, that a man, or indeed in these days anybody, must be able to consult his lawyer in confidence since otherwise he might hold back half of the truth. And really, there can be no effective access to legal advice if there's a niggling fear that the facts or documents or whatever you disclose to your lawyer might come back to bite you in the backside. As for litigation privilege, as again we'll come on to cover, the privilege here really exists to protect communications between a lawyer and a client made in the course of litigation or where litigation is contemplated. And really the English cases have come round to say that this really exists to protect a right that's now embodied in the European Convention of Human Rights, the right to a fair trial. And as Steyn LJ said in the ex parte Leach case, which I've got there on the slide, it's really the unimpeded right of access to a solicitor for the purpose of receiving legal advice and assistance in connection with the possible institution of civil proceedings, which forms an inseparable part of the right of access to the courts themselves. On the next slide, I've tried to draw together really the threads of the cases. It seems that there are two distinct justifications for each limb of the legal professional privilege, which we enjoy in this jurisdiction. But really, as the editors of Zuckerman on Civil Procedure note, fundamentally, all of these, both doctrines exist, or both limbs of the same doctrine exist, to create, as we see in the first line, a private and secure sphere in which we can obtain legal advice.
So on the basis of that doctrine, in practice, why does it matter? It provides an absolute right to withhold a document in the course of a litigation or to prosecuting authorities or regulators. There's no discretion by the court once privilege is established that provides a right to withhold that document. There are some very rare statutory exceptions, the main one being under the Regulation of Investigatory Powers Act, and that's related to covert surveillance and in cases of national security. So hopefully not necessarily that relevant in daily practice for most of us. Its documents still must be disclosed in the sense that they must be listed out. It's not the existence of those documents that one's got a right to withhold, but it's the document itself. Albeit with many commercial cases now being subject to the disclosure pilot, you're moving on a little bit from separating out disclosure and inspection and a bit more focused on targeted requests for documents. But and the withholding and the assertion of privilege can give rise to no adverse inference. So that's the doctrine in practice. So legal professional privilege, as we know, has two limbs. The way that we've structured this is we're just going to break down firstly legal advice privilege into its component parts, and then move on to litigation privilege and just discuss those aspects in which it differs from legal advice privilege. The definition of legal advice privilege is up there on the slide: a communication made in confidence between a lawyer and client for the dominant purpose of giving or receiving legal advice. Breaking this down, a communication. So obviously that applies to any email or correspondence, for example, passing through calls or notes of those calls. It does also apply even if there is no actual communication between the lawyer and the client. Any material that's produced by a lawyer during the course of their retainer for the purpose of legal advice. For example, a lawyer preparing some notes in preparation for a call or meeting with their client. But be careful, it doesn't apply the other way around. For example, if a client produces a document with no intention of ever communicating that to their lawyer, albeit it might be for the purpose of later seeking legal advice. It's between a lawyer and a client. Let's look at the lawyer first. And this is where we see that it can really become quite tricky for in-house lawyers, because sometimes an in-house lawyer might be acting in their capacity as lawyer, other time as client, and other times arguably as neither. But this element of the test has some aspects that aren't too complicated. Members of the legal profession in England, solicitors, barristers, it does apply to in-house lawyers. Foreign lawyers, that's a question we had in advance. They do count as a lawyer for the purpose of privilege, and there was a case that examined this in some detail and found that courts will not be too concerned into looking at how those lawyers are qualified or regulated, or won't get too technical about it. When it comes to foreign lawyers, it's the function that they're performing that counts, as opposed to necessarily their status. Lawyer, the definition of lawyer for the purpose of privilege includes authorised persons that are regulated to carry out specified legal activities, for example, legal executives regulated by SILEX, licensed conveyancers. Also extends to lawyers and employees when supervised by lawyers, for example, paralegals or trainees. It does not, though, extend to, for example, tax advisors, even when they are providing legal advice. And the authority for that is a case called Prudential, where the Supreme Court declined to extend the doctrine of privilege to advice given by PricewaterhouseCoopers relating to tax liability. I've got a client on the other side, and this is where really it can get really tricky for in-house lawyers. If we first start from the principle of client, so not third parties, for example, where in practice it can become, well, it's easy to get in trouble with this aspect, is the appointment of experts or ex-employees, for example, that might be potential witnesses, or instructing a third party to conduct investigations. If that communication between a lawyer and a third party, that is not covered by legal advice privilege, although it could be covered by litigation privilege, which we'll touch upon if the relevant tests are met. Now, what about when the client is a company? Mark, does it mean that every single employee of that company is the client?
Yeah, thanks, Paul. And this is a really difficult and unsatisfactory area of the law, and it's not just me saying that. It's much cleverer, more senior members of the legal profession. You're right to say that, or to imply that it's not every employee of a company who produces a document who might be entitled to claim privilege in respect of that document. It's really only employees who are authorised to seek and receive legal advice on behalf of the company. And that test goes back to a decision in 2003 of the Court of Appeal in the long-running Three Rivers District Council and Bank of England litigation. We're on decision number 5, which we're particularly interested in. Just a quick recap. I'm sure you'll all be familiar with it, but in that case, it was a local authority, the Three Rivers District Council, who was suing the Bank of England in relation to losses that they'd suffered arising out of the failure of the BCCI Bank, which had been subject to the Bank of England supervision. Now, the role of the Bank of England and their supervision in the failure of BCCI had been the subject of an inquiry by Lord Bingham, the Bingham inquiry. And for those purposes, the governor of the Bank of England had set up the BIU, or the Bingham Inquiry Unit, which consisted of only 3 Bank of England officials. And it was those 3 officials who were specifically tasked with dealing with communications between the Bank of England and the inquiry. And for those purposes, the Bank of England engaged Freshfields. Now, as Pauline is going to touch upon, an inquiry is not adversarial litigation. So litigation privilege couldn't attach to it. So the question was whether legal advice privilege could attach to communications created by employees handed to the Bingham Inquiry Unit for the purposes of obtaining legal advice. In light of the test that is articulated on the slide, the answer to that was no. And the Court of Appeal even said that even if the governor of the Bank of England had noted down various facts and matters with the intention of giving it to the BIU for transmission to Freshfields, no privilege would attach to that communication, because it's only those who are authorised to seek and receive legal advice on behalf of the company. And as the governor of the Bank of England wasn't alleged to be one of those individuals, he fell out with the scope of any of that protection. Now, the test in Three Rivers, i.e. Whether or not the communication emanates from an employee authorised to seek and receive legal advice on behalf of the company, still remains the law, albeit with its dissenters, indeed some of whom are quite powerful. There's two Court of Appeal decisions in particular that I just want to talk about briefly. The first is the Serious Fraud Office and Eurasian Natural Resources Corporation Limited case from 2018. In that case, the Court of Appeal were quite trenchant in their criticism of Three Rivers, although they were constrained to accept that Three Rivers was good law and that any departure from it would have to await a decision of the Supreme Court. They did say that Three Rivers was particularly unsatisfactory because it seemed to disadvantage large corporations who in the modern world have a whole number of employees who may have first-hand knowledge or experience which is relevant to the giving and receiving of legal advice. And it seems somewhat bizarre to exclude those individuals and their communications from the protection that would otherwise be provided by legal advice privilege. Indeed, the Court of Appeal noted that the way the doctrine is currently framed seems to favour small companies and give them something of an advantage in seeking and obtaining legal advice. Three Rivers has not been followed in other common law jurisdictions, which means that the law as it is in England is out of step with the common law, something which very much upsets the Court of Appeal. It did in 2018. It continued to upset them in 2020 in the R on the application of Jet 2 case and the Civil Aviation Authority. They again said that they were constrained to accept that Three Rivers was good law and that the analysis of the Three Rivers case in the Eurasian Natural Resources case bound them. However, they urged the Supreme Court to consider this, and they raised two further issues with the doctrine as it currently stands. One relates to internal communications for the purposes of settling instructions, which is potentially relevant to in-house lawyers. And it's really unclear how that sits with the proposition in Three Rivers. And the second, to my mind, more interesting criticism raised was the apparent inconsistency in relation to the collection of information for the purpose of instructions and then the transmission on to lawyers and then the dissemination of the work product when it comes back, which, as we'll come on to, may well be covered by legal advice privilege unless there's a waiver. So sadly, we're stuck with individuals authorised to seek and receive legal advice on behalf of the company, but that may well change.
Thanks, Mark. Yes, it's, worth bearing in mind it can cause, real difficulties for in-house lawyers. Situations we might see sometimes in practice is, for example, an employee on the ground, say in charge of a particular contract, but not otherwise authorised to seek or receive legal advice, might have been tasked by the internal legal team to say, well, how about you gather a list of the ways in which we haven't been complying with our contracts? And, evidently the difficulty with that not necessarily being privileged in potential litigation that was not contemplated at the time can become so huge difficulties there, really worth treading with care. And frankly, if in doubt, maybe seek advice as to whether a particular document or communication might be privileged before you instruct it. Right, confidentiality, a requirement of legal professional privilege, both limbs. The key is that the document has got to be confidential when created in order for privilege to attach in the first place. If you've released, if you made a press release, for example, you can't then claim that it is privileged and that you can't provide it to the other party in a litigation. Another example, potentially less extreme, but say an email by a lawyer giving legal advice, but copying more than just the client and copying other parties, arguably not confidential in the first place, and so privilege wouldn't attach. Another difficulty in practice is that the law does recognise, say, once a document is privileged and legal advice privilege attaches, the law does recognise that legal advice has not been obtained in a vacuum and may need to be communicated internally, for example, to the board or to employees who might need that for the purposes of their work. So in certain circumstances, advice can be disseminated without necessarily losing privilege, but one must tread with caution because loss of confidentiality can indeed lead to the loss of privilege. Mark, I think you had one case to mention on this front.
Yeah, the good luck, a case about a ship, it seemed to me to be particularly relevant. In that case, the issue was whether or not breaches of duty by insurers had been causative of a bank lending money to the owners of a vessel. Now, the bank had obtained some legal advice and then had disseminated that legal advice internally to the people who are going to make the commercial decision about whether to lend. And it was argued there that because the communications had been disseminated, that they'd lost their confidential quality, and therefore privilege had ceased to attach to them. But that argument was summarily rejected. The confidential nature of the communication is not lost simply by its dissemination, and certainly not when the advice is put to the commercial use for which it was obtained. But I think Pauline's right. Treading carefully and heading communications appropriately is particularly important when communicating internally.
I think with privilege generally, treading carefully is probably the main rule. But as you say, ensuring that any dissemination of advice is done under strict terms, marked confidential. If it's got to be shared externally, for example, for a purpose related to that legal advice, consider entering into agreements relating to confidentiality. But again, treading carefully is really required. I've put on there that there's a distinction between the document itself and the content. Mark's going to talk about waiver later, and that's slightly different. But in terms of confidentiality, that is not necessarily lost by the existence of a document being revealed. There was one case of Raiffeisen Bank where the court found that a solicitor confirming the nature of his instructions, that did not mean that the actual communication by the client providing those instructions had lost confidentiality such that it would lose privilege. Dominant purpose test, again, is key. So here we're talking about legal advice. So the communication must have come into existence for the dominant purpose of giving or receiving legal advice. Again, must have come into existence for that dominant purpose. So if there's a document that predates the need for legal advice, but that is sent to a lawyer for the purpose of receiving legal advice, that would not be privileged. Another big area of difficulty for in-house lawyers, it is legal advice. It is not purely commercial or administrative. So as in-house lawyers, particularly if your role is slightly mixed, make sure you think about which hat you are wearing when you're making a particular communication. Again, the same point about not being in a vacuum. Obviously, legal advice can come with some commercial connotations, so the courts aren't overly technical about it, and this is taken to mean what should prudently and sensibly be done in a relevant legal context. So it can include commercial advice given through a lawyer's eye. One looks at the continuum of communication rather than necessarily at a pure granular level, whether a specific email might contain a specific legal advice or request for legal advice. For example, a client might want to update their lawyer who's instructed on a particular matter. That might purely, the email itself might purely contain an update and facts rather than a request for legal advice. But if that is within the context of the lawyer's general retainer in order to seek legal advice on a particular matter when needed, that would still fall under the doctrine of privilege. Although remember, the other elements need to be met. This is, we're looking at the dominant purpose test here. Mark, you're going to cover some of the position as to material that tends to reveal legal advice.
Yes, I mean this is interesting and goes back some 150 odd years now, particularly for in-house lawyers who may be dealing with commercial agreements which might be said to reflect the contents of legal advice, which has been given or has been obtained. There used to be I say there used to be, and I'll come on to explain why I say that, a principle whereby a selection of documents that had been copied by a solicitor, which betrayed the trend of legal advice given by the solicitor, was privileged. And that was because the disclosure of those documents would give the other side a clue as to the advice that had been given by the solicitor, and an insight into the professional opinion that they had obtained. Now, that was a case from 1884 when copying of documents was much more difficult than it is today. Indeed, the examples given by the court in that case included rubbings of gravestones. I don't think anyone takes rubbings of gravestones anymore. That was a 19th century principle, the ratio of which was said by Lord Bingham in a case called Venturis and Mountain to be that where the selection of documents does betray the trend of advice, then those documents are privileged. And he said that really gives effect to the principle that we discussed right at the outset, which is one of fairness. It would be unfair if the other side were to get an insight into the advice which I had obtained on an all cards on the table basis. But that application is really of very little, if any, that principle rather is really of very little, if any, application today in light of a Court of Appeal decision from the beginning of the century, because it doesn't apply to selections of documents which are in control of the party who are making the selection. So in other words, what you can't do is put a bundle of documents together for counsel and then say that those documents are privileged. So that's important. But there are some remnants of that principle today, where a document contains or gives a clue as to the legal advice that has been obtained in a more concrete way. In the Excalibur Ventures case, Mr. Justice Popplewell had to consider whether funding agreements should be disclosed, litigation funding agreements. The argument in that case was that if those agreements did betray the advice which had been given in connection with the merits of the funded party's claim, and he accepted in that case that if there was such an indication in those documents, it would be covered by legal advice privilege. But we shouldn't push this principle too far. That's illustrated perhaps most colourfully by a 2009 decision in the case of Immerman and Cheng Gui's. Now, in that case, for some bizarre reason, only originals of the documents existed, and the lawyers, instead of copying them and annotating them, annotated and highlighted the original documents. And in that case, it was submitted that the annotations and the highlights showed a trend of legal advice, but not just that, but the documents which weren't annotated were also privileged because the fact that they weren't highlighted betrayed the lawyer's views on that particular document. Needless to say that those submissions were rejected as slightly far-fetched. In highlights and annotations and really anything else which stops short of noting down what the content of that legal advice actually is, any objection based on those grounds, I think, is unlikely to succeed. More recently, it's been said by Mr. Justice David Richards, as he then was, that there's a distinction to be drawn between a case where there's a definite and reasonable foundation in the contents of the document for the suggested inference as to the substance of the legal advice given, and merely something which would allow one to wonder or speculate whether legal advice had been obtained, and if it had been, what the substance of that advice was. And the Immerman case is really in the latter category. the highlights would lead one to speculate whether advice had been taken and what that advice might be. But there was nothing of substance in those documents. So the principle is really narrow, and it's not going to be easy to persuade a court that a document which is not otherwise privileged should be treated as such, because even though it neither contains or evidences legal advice, it provides some clue as to the advice that might have been given. But there will be cases where there may well be, in a commercial arrangement, excerpts which do give rise to give rise to the reasonable foundation as to the merits of legal advice that's been taken. But those cases are going to be rare. I had recently, speaking from personal experience, a case where a client was very unwilling to disclose a funding agreement. The argument was something along the lines of the commercial terms of the funding agreement, which were particularly unfavourable to my client, reflected that they had received advice that their claim was actually bad, although good enough to get funding. Needless to say, that was not an argument that I don't think would have found favour with the judge, stopping it, because it simply didn't contain or evidence sufficiently enough the legal advice which had been given in relation to that claim.
Thanks, Mark. Those are the component parts of legal advice privilege, really. In summary, for in-house lawyers, I thought it might be helpful to list some questions that might be good to ask yourself before sending a communication. Am I acting as a lawyer and giving legal advice? Am I acting as a client and seeking legal advice? Who am I copying this to? And do they know it's confidential? Obviously, these questions, it's not just in-house lawyers asking, creating communications and creating documents. So we'll touch upon later as in-house lawyers, one thing to consider potentially is training non-lawyers about the principles that we're covering here. Litigation privilege is the second limb of legal professional privilege, and there are some principles that are very similar. So I'm not going to go over those again in terms of what might constitute a communication. There's also a dominant purpose test, but the actual purpose is different here. It would be relating to litigation, and similar considerations as to confidentiality. Some of the key differences, though, are that in litigation privilege, you don't get into all of the difficulties that we did with legal advice privilege in considering who the client might be, because it can attach to communications that are between a lawyer and a client, or between either of them and a third party. It can be through an agent, provided that agent is purely used to communicate, but again, would urge caution when communicating through agents, or can attach to documents created by or on behalf of a client or a lawyer, provided the other elements of the test are met. What do we mean by litigation? As Mark touched upon earlier, it's been defined as adversarial litigation, not purely investigative or inquisitorial. So, for example, it includes arbitration. It would not strictly include inquests per se, albeit, I mean, I act on a number of inquests where one might be forgiven for thinking that they are adversarial, but it's been held that no, they are, that they're not strictly adversarial. I say per se because, again, purely being in contemplation of an inquest would not fall under litigation privilege, but certainly there are certain inquests where the inquest might be in consideration, but also potentially some criminal prosecutions that might be, say, almost certain to follow from the events. So that is something to bear in mind as well, because criminal prosecution certainly is adversarial. Investigations by regulators, prosecutions, that's where, again, you can get into a bit of trouble. There was a case relating to the FCA where, fortunately, the court declined to actually make a finding because it related to without prejudice. privilege, but the implication seems to be that FCA investigations are adversarial from the start, but there was no clear finding. So again, might be a bit difficult. SFO investigations, that's another question mark. It's unlikely that, you know, the merest interest by the SFO, service of a notice, or, you know, the start of concern by the SFO necessarily constitutes adversarial litigation, but certainly if actual, you know, criminal prosecution or consequences are likely to follow, then that gives a good argument for contending that litigation is in reasonable contemplation. Here is this element of the test, that the litigation must be pending, existing, or reasonably contemplated. Mark, you've dug out the United States and Philip Morris, which...
Yeah. There's just a helpful statement there as to what reasonably in prospect actually means, although I sometimes find it's one of those tests that actually, when it's formulated, doesn't really help one any further than asking whether litigation is reasonably in prospect. Yeah. But that might be of some assistance.
Yes, real likelihood rather than mere possibility. There's a lot of case law about this, where ex post facto, the court had to ask themselves, what stage were we at really? It has to be more than a general apprehension that litigation might follow because there's, you know, potential breach of contract, say. But I agree, it's one of those tests that really in practice can become a bit difficult to delineate. So the litigation must be adversarial, it must be in reasonable contemplation, and the document must have been created for a dominant purpose of what, in relation to this litigation? It's been held to be of giving or receiving legal advice in connection with the conduct of litigation, collecting evidence or information for use in that litigation. And there's another point that I think is of difficulty and worth flagging. So it's got to be in connection with the conduct of litigation. So of course that includes going through the different phases of proceedings, producing documents, etc., etc. It does include consideration of whether to litigate. It does include consideration of whether to settle. But it has been held not to include discussions that purely about a commercial settlement, even if it is of litigation. That comes from the case of West Ham United and E20, related to some emails that were internal to the board. So between board members that purely related to, you know, to numbers and to the commercial settlement. So again, very much worth bearing in mind. One point is that, you know, unless these commercial discussions are inextricably linked with the other elements of the test, for example, advice relating to litigation. So very much a point of caution, but one thing to bear in mind, for example, might be when discussing settlement, are you discussing this settlement in a way that is inextricably linked to the advice that you have about the prospects or the merits of a particular claim? If so, then that document or communication is likely to be covered by litigation privilege. So generally what you look at in terms of the purpose, it's the purpose of the procurer of the communication. So there was a test that I thought was quite interesting that was about Property Alliance Group and RBS. Here, a claimant met former RBS employees. Those former employees thought that they were discussing business opportunities when, in fact, the representatives of the claimant had, actively deceived them. But what they wanted to do was to gather evidence, really, for the purpose of litigation. In that case, the court found, they declined the claimant's argument, basically, that litigation privilege should apply to those notes because actually they'd completely deceived the other party as to the purpose of that. Although, Mark, I think you had some views about how that case was decided.
Yes. I mean, I think it's important to underline that the thrust of the authorities is that the test is objective, albeit in that case, objectivity was assessed from the perspective of the deceived party. So it's difficult to see how it was objective. But perhaps a better analysis might be that objectively, the purpose of the meeting was reflected in the communications, i.e. they were invited in for business discussions, not to talk about potential claims. So perhaps something to bear in mind there.
Okay. So that's it for the component parts of the legal professional privilege. Just some general points on privilege is that it belongs to the client. The lawyer cannot choose to waive privilege unless, of course, instructed by the client to do so. It survives the end of a lawyer-client relationship. It continues for successors in title. One question that we had in advance as well was what happens on a liquidation. In that case, it is the liquidators who can choose to waive privilege on behalf of a company to which the privilege belonged to in the first place. If a company is dissolved, therefore the company doesn't exist anymore, then there is actually, the analysis isn't, oh, well, there's no one left in existence to maintain that privilege. Privilege stays, and in fact, there is no one left to waive that privilege. So unless the company is restored and then waives privilege, then privilege will continue to attach. A note that there is a particular position when it comes to bankruptcy. Privilege is not property that passes to the trustee in bankruptcy. It's been held to be such a fundamental, human right that privilege still belongs to the bankrupt. The trustee would be entitled to bankrupt's privileged papers if they relate to the bankrupt's estate or affairs, but the trustee cannot do so in a way, cannot deal with those papers in a way that would amount to waiver. Finally, the iniquity exception, just worth bearing in mind that no privilege attaches to documents or communications between a client and a lawyer where the purpose of the client was the furtherance of crime or other iniquity. But I'm sure that would never be relevant to any of our attendees.
Thanks, Pauline. I agree. And I just wanted to touch briefly on waiver. Before Pauline comes on to talk about without prejudice communications. Now, waiver is another horrifically imprecise term, and it's not just me that says that, but much higher authority now, Lord Leggett, but he then was in the Mohammed and MOD case. And he summarised 5 ways in which privilege may be lost. He talks about true waiver, which is consent, express or implied, to the use of privileged material, and that can either be general or limited in scope. You've then got collateral waiver, where you deliberately deploy material. What you can't then do is assert privilege in respect of some aspects of material which relate to the stuff that you've disclosed. In other words, what the court will be keen to do is to prevent you cherry picking the bits of privileged material that you want to rely on. The third category he talks about is professional negligence proceedings. A client can't assert privilege in relation to communications which relate to the issues before the court. There's been held to be an implied waiver in those cases, and indeed the litigation wouldn't be able to function if that weren't the case. There's then loss of confidentiality, which Pauline's already touched upon, where a communication loses its confidential nature. We can't assert privilege in respect of it. And then there's the interesting case of possession, and that's where a party comes into possession of privileged material. There's an implied waiver subject to the court's jurisdiction to restrain a breach of confidence. And I'll come on to talk about some specific examples under the CPR and practice direction in a moment. So far as waiver is concerned, what underlies it is a fundamental principle of fairness, and that really runs like a thread throughout the entire doctrine of privilege. And as I've said, you can't allow a party to cherry pick what documents are disclosed, where to assert privilege and where not to assert privilege, where it suits an individual or a company. And the test, I wonder if, Pauline, you wouldn't mind flicking over to waiver 2. As to whether there has been a waiver, is set out in the Brennan and Sunderland City Council case. And again, it's underlined there that the fundamental question is one of fairness. As for particular cases, statements of case, once they're filed, cease to be privileged. While they're in draft, they obviously are. But when they're filed at court, they become public. As to affidavits, now that's more interesting. Draft affidavits are privileged. Once served, however, it's slightly more interesting, and there's perhaps a distinction to be drawn between affidavits and witness statements. The latter having an implied undertaking as to collateral use attached, and there's a question as to whether that applies as to affidavits. Witness statements, like affidavits, privileged in draft, but once served and prior to being given an open court, are subject to that undertaking, only to be used for the proceedings in which they're served. And we find that in Part 32 of the Civil Procedure Rules. Documents referred to in an affidavit or a witness statement, there's an absolute right of inspection in relation to documents referred to in affidavits or witness statements, or indeed statements of case, such that privilege will held to be waived in respect of documents where they're referred to. Instructions to experts, this again is difficult, along with expert reports. There is a right of inspection, both under the Civil Procedure Rules and Part 31, and also the new practice direction on disclosure, in relation to documents referred to in an expert report. So when your expert lists out the documents they've been referred to, be careful not to provide privileged documents to experts, because referring to them in a list, as experts are wont to do at the beginning when they have to set out what materials they've considered, might lead to an inadvertent waiver of privilege. Disclosure, where there's been an inadvertent disclosure, then this is the fifth category of case that Legate J, as he then was, talks about. There is an implied waiver, but that's subject to the court controlling the use of the document and intervening, for example, by way of injunction. And where, for example, the disclosure is the result of an obvious mistake, then the party to whom the document has been produced will most likely be restrained from using that document and ordered to destroy it. Now, as to the subsequent use of documents, disclosing a document in one set of proceedings doesn't necessarily operate as a blanket waiver of privilege as against the world. Indeed, documents that have been disclosed for the purposes of one set of proceedings can't be used in a subsequent set of proceedings without permission of the court. Obviously, that doesn't apply to where those documents have been referred to in open court. But where you're advising a client and there's litigation on multiple fronts, you have to tread particularly carefully here. Indeed, recent experience dictates that one has to go through the transcripts of evidence particularly carefully to see what was referred to and how it was referred to avoid breaching that undertaking not to use documents disclosed in subsequent proceedings. There is a discretion for the court to order documents previously produced in proceedings to be used in subsequent proceedings. But that's a high hurdle, and it really needs to be in the interests of justice for those documents to be used in the subsequent proceedings, and there really needs to be a lack of injustice to the disclosing party.
Thanks, Mark. Right, without prejudice privilege, another clear category of privilege separate from legal professional privilege. I'm not going to go into it in detail. I'm sure we're all on this webinar familiar with the concept of without prejudice privilege. It applies to genuine attempts to settle an existing dispute. The policy reason is clear. In order to encourage settlement, parties must be able to be frank, potentially make some admissions, some offers without fear of, if that does not lead to a settlement, that then being used against them in court. It is the substance, not the label, that matters. You can't head something without prejudice and call someone names and be happy that that won't be put before the court. The reverse is also true, that something cannot be headed without prejudice and still be protected by the privilege. But obviously, be careful, and it does help to use correct labelling. It avoids potential inadvertent waiver by something being, accidentally disclosed. It's just best to try to keep to that. One difference, one point to bear in mind in terms of the substance, not the label, is that is the difference between without prejudice, which can never be shown to a court, and without prejudice save as to costs, which can be taken into account by a costs judge, for example, to demonstrate that you made reasonable offers in an attempt to settle. There's case law that shows that you can't imply without prejudice save as to costs. If something is a genuine attempt to settle and has no label, it might be inferred by a court to be without prejudice, but it will not be inferred to be without prejudice, save as to costs. I'm conscious of time, so I'm not going to spend too much longer, but it applies to the whole of a document unless clearly separable. For example, different headings, one part being without prejudice and the other part being open. But again, best to avoid and keep things separate. Might avoid inadvertent disclosure. On purely practical terms, it means that you won't need to have a paralegal redacting parts of documents for disclosure when it comes to that. And I've put some exceptions to the fact that without prejudice communications cannot be shown to a court. For example, if it turns out that one party argues that actually a settlement was obtained by fraud or misrepresentation, then those communications might have to be deployed. Or if there's an argument as to whether a settlement has been concluded at all and on what terms. Common interest doctrine is, it's not privilege in itself, but it preserves privilege when disclosed to third parties with whom you've got a common interest. For example, co-defendants, outside the scope to consider that in detail, but a document must be privileged in the first place in order for common interest then allows that privilege to remain if a document is shared with a third party. In practice, it's for the party claiming privilege to prove that privilege applies. Generally speaking, evidence can be provided by way of an affidavit asserting that privilege applies, but that's where you can get into difficulty for obvious reasons, because giving too much detail to prove this can defeat the very purpose of privilege. So that can get tricky in practice. Practical tips, finally, for in-house lawyers. As we've seen, defining the client for the purpose of a legal advice privilege can be quite key. So define and document the client. If there's a particular matter, perhaps create a group that is clearly authorised to instruct legal advice or receive it. Use labels, appropriate labels, try and separate privileged and non-privileged material. Be careful when circulating, only on a need-to-know basis and under strict terms. For example, this is privileged and confidential. Do not forward it. Do not share it. If there's any doubt as to whether, for example, litigation privilege applies, or whether any sort of privilege applies, pick up the phone. Refrain from creating new documents if possible, rather than creating communications that may or may not be privileged. Perhaps record when litigation is in contemplation for the purpose of litigation privilege. And finally, all of these points that we've seen are really, they're really tricky. And in practice, non-legal staff members will be creating as many communications as you and perhaps not understanding. So it's a good idea to train non-legal staff members about some of the key points to make sure the privilege attaches. And finally, in terms of internal investigations, as we've seen, that can be particularly tricky to see whether privilege applies. So just set on the slide some top tips that might assist with privilege attaching, for example, having them conducted by lawyers, advising any interviewees, for example, employees, that this conversation is privileged, subject to litigation privilege, for example. The privilege is the company's, and it is only the company that can waive privilege. And finally, again, picking up the phone or, consider reporting orally. There we go. On the note of the final slide, and we've got a few minutes for questions. Yes, the slides will be made available. If you mark something legally privileged and confidential, is this sufficient, or does it need to be marked legal advice privilege or litigation privilege? Wouldn't want to lose privilege for not using the correct wording. Mark, feel free to jump in. In my view, it doesn't matter. You can't lose it just by only saying that something is legally privileged and confidential. In fact, just marking something legally privileged does not make it so. It just assists with making sure that everyone is aware of privilege, avoiding accidental waiver, etc. But legally privileged is sufficient and confidential. In fact, one might argue that perhaps best to keep your powder dry and leave yourself the option of arguing either.
I certainly endorse keeping powder dry.
One thing that you often see is, and or legally privileged, prepared for the purpose of seeking or obtaining legal advice / for litigation that is reasonably in contemplation. Can get a bit wordy, but just best practice really. And again, if non-legal staff members are trained in all of this, just using the correct labeling might ensure that they bear these points in mind, that they remember the training, maybe giving a standing instruction that if they're not sure, they should approach you to double check whether an email can be sent or that sort of thing. Any more questions? We've covered a fair bit of ground as a whistle-stop tour. There's a lot more detail that could be gone into. Entire books have been written about this. What I would say is we're very happy to answer any questions. If ever there's a concern, pick up the phone. Right, if you obtain a single expert report for the purposes of legal proceedings, but it is not favourable, and you decide to obtain a second report, does the former report attach privilege? Yes, if you obtain obtaining an expert report for the purpose of litigation is subject to litigation privilege. Obviously, once you serve a report and rely on it, that then is no longer privileged. One word of caution is using the same expert, because expert's duties is to the court, so that expert would not, well, obviously, unless the terms of the instruction change, one would assume that the expert would come to the same conclusion. But yes, you can go to a different expert and try again, I would say. Would a planning inquiry count as litigation? Inquiries generally do not. I have to say, I've not considered that point in detail, whether there's any case law that decided on that, and whether planning inquiries have any peculiarities that means that they would count as adversarial as opposed to inquisitorial. But on the face of it, the test is not inquisitorial, but adversarial. Okay, well, it is 3:01. Thank you everyone for joining us. Thank you, Mark. And if you can take the time to fill out the feedback form, and certainly do get in touch if there are any questions about this topic and if we can assist further.